All right, let's try that again. Welcome, everyone. I am Leonard French, your favorite technical difficulty overcoming copyright attorney. Let me know if you can see me now. Can you see me now? We'll see if this works. well, there's the black screen's supposed to be there. All right, excellent. So sorry about that 3-minute delay there. Usually I have these live streams set up to automatically start when I hit streaming on my end, and for some reason it was set up that I had to go into the streaming controlled live control room on YouTube and start it there. So apologize for that. Welcome everyone. I did see and actually responded to all of your donations. So thank you very much to Matthew East and Matthew Anderson and Matthew West. No, I'm kidding. And Aspernari and John Roddy. And welcome everyone. Yes, I did a whole introduction for you and then discovered that YouTube had not converted the live stream to a live stream. It was instead just I don't know what it was even doing. And then trying to get the timing of starting the stream and then starting the YouTube, whatever. You got it. So welcome, Sir Gregory Groda. I should read up on my function in May's EU election, but then there is French time on YouTube. Thank you for the Swedish kroner 50. Appreciate that. So we'll get started here in just a moment here. What we're here for today is an update in the Watchtower Bible and Tract Society versus, well, it's not really a versus, it's a subpoena to Reddit for Reddit user Darkspilver's identity. And the whole thing is sort of, well, you'll see. If you haven't heard about this before, I'll go into the details before we get into what's exactly happening now. But there's an update. The big news that I've already revealed is that Reddit has gotten involved, and we actually don't have too much more about that, but I can give you some inside information. And then the EFF and Darkspilver have responded with their reply in support of their motion to quash. So that is what we're primarily going to go over today. So welcome everyone. There are so many of you. Let's see. Last I saw, there were 264 of you watching. That's really cool. We will jump right in. I'm not going to waste any of your time or mine today, because what's happening is the Electronic Frontier Foundation has filed their reply in support of the motion to quash the subpoena that Watchtower sent to Reddit. This happened first, so we're going to go over this first. Don't worry, I'm not going to short you on the other news, but we have to go over this first so we understand what's going on. So the Watchtower Bible and Tract, one of their, or I think the Pennsylvania organization, filed or sent a 512H subpoena to Reddit. 512H is 512H of the DMCA, which is section 17 of the United States Code, so 17 USC 512, and then subsection H deals with sending just a subpoena, not a lawsuit, not otherwise yet involved in a lawsuit, but just sending a subpoena to a service provider for a copyright infringer's identity. Well, breaks. Why are we here for a copyright infringer's identity? What could a person possibly have done to a Watchtower Bible and Tract Society organization? Well, the accusation is that this person posted on Reddit a flyer, which I don't think I have it in today's documents, but basically it was a colorful flyer, sort of minimalistic design, like one color. I think it was blue and white, and then the text was all about how to donate to Jehovah's Witness organizations, Watchtower, etc. What website to go to, how you can do all this. Then the other thing was some kind of chart to do with the General Data Privacy Regulation, Article 30 in the EU. It was a chart of how they handle different situations there. So we had done an edited video, or a video that was edited from a live stream, and then we did a live stream about the couple the things that were involved, the subpoena itself, and then the motion to quash that was filed by the Electronic Frontier Foundation and Darkspilver. And the motion to quash is a motion to get rid of or vacate the subpoena, or the order that granted it in the first place. And that usually has its own set of rules about needing to be an undue burden, or otherwise, somehow be invalid. And Darkspilver had argued that this was a copyright claim, but not really a copyright case, because Darkspilver is really just a member of the Jehovah's Witness organization who sometimes criticizes and posted this flyer on Reddit along with a commentary on the comments page for that post, as well as same thing with the chart. And this might not be copyright infringement. Is a chart and a flyer that you're posting and commenting on, that sounds a lot more like fair use. Or I even argued that this might be de minimis copyright infringement, if at all. But we're not there yet. There is no lawsuit where you would then assert a de minimis copyright infringement. Well, sort of. That's going to come into it. Let's start here with the Electronic Frontier Foundation's reply and support. So we've already got the motion to quash filed by the Electronic Frontier Foundation. We already saw that the Watchtower attorney had responded and, in support of the subpoena and against the motion to quash. And their argument was very much that the motion was not timely, or yes, it is a copyright infringement case, and if you take away our ability to subpoena, then we have no teeth in the realm of copyright. And it just seemed to me, and I left with a bad taste in my mouth for the tenuous nature of the copyright case. Why would copyright be used in this case? It doesn't really apply to this case. This seems more like a breach of some kind of confidentiality. You have an organization that has a mole, so the best you can do is sort of trade secret or some sort of contract violation. But speaking to some other former Jehovah's Witness members, I actually don't remember if they were former members or just critical of, and in support of former members and critical of the organization's policies. But we had a live stream, and this seems to be a thing. Everyone was very concerned that this subpoena process was being used to get the identity, not to enforce copyright. That the primary motive here was the identity. So, lo and behold, we get to the reply, and it says, Watchtower, this is the EFF speaking, or Darkspilver speaking through the EFF, Watchtower has not and cannot support a copyright claim. It has failed to show that it owns any valid copyright. The chart, for example, is factual and legal information. The ad and the chart's use are for nonprofit and educational purposes, for commentary, and they are classic fair uses, not infringement. Then they go into First Amendment, that the First Amendment does apply to a court compelling the disclosure of an anonymous speaker's identity, that the First Amendment limits government action abridging speech in the United States. The cases cited by Watchtower that were in support of their subpoena and against the motion to quash, those cases do not involve the First Amendment or U.S. court orders. The signature management case confirms that anonymous speech activities receive First Amendment protection in copyright litigation. Then they explain why the motion to quash is timely, which had been one of Watchtower's rebuttals. And there's a section here, I read this in advance. There's a section here about a little slip, a little fumble that Watchtower may have made in something they pointed out, and we'll see how big of a fumble that may or may not be. So we're going to cover this, and then we'll get to how Reddit has joined, and you'll understand a little bit why I did it in this order. Watchtower is asking the court to unmask a speaker based on pretextual copyright claims Watchtower has not and cannot support. Doe posted the images at issue in a community of self-identified former Jehovah's Witnesses for the purpose of sparking and informing discussion of important issues, a powerful organization's handling of personal data and its solicitation practices. One of the images is both unregistered and unoriginal. There is nothing copyrightable that could be infringed. The other is a copy of an advertisement available for free online. In both cases, the posting is classic fair use, not infringement. If Watchtower ever filed a lawsuit, it would fail on the pleadings. Thus, on the one side, we have a set of facially deficient copyright allegations, on the other, a powerful likelihood of irreparable harm. Watchtower acknowledges that Doe has been commenting about the Jehovah's Witnesses for years. They have stopped in an attempt to stave off further risk of exposure. If Watchtower prevails in learning Doe's identity at this early stage before any adjudication of infringement, the damage will be permanent. Doe will have already lost what matters, the ability to speak anonymously about important matters of public concern, like a powerful organization's handling of personal data and solicitation practices. In these circumstances, under either the test set forth in Highfield's Capital Management versus Doe and the Art of Living Foundation versus Doe's 1 to 10, or the Basic Rules of Civil Discovery 26 and 45, the subpoena should be quashed. The cases Watchtower cites, including Signature Management, only confirm it. Contrary to Watchtower's claims, the domestic effects of orders affecting speech have, in other cases, justified the application of the First Amendment even where the speaker is not a U.S. resident. The chilling effects and loss of access to Doe's speech are harms that directly implicate the First Amendment and will occur in this country as a result of a judicial order executed in this district. The court should reject Watchtower's effort to avoid well-established First Amendment protections for anonymous speech. Watchtower's timeliness objections are also misplaced. The 14-day deadline for objections has no bearing here. Doe did not receive the subpoena and could not have objected, nor is Doe a party in any ongoing litigation. Doe's only option was to move to quash. Doe pursued that option with appropriate diligence, particularly given Doe's lack of advance notice, location outside the U.S., limited resources, and lack of experience in litigation. Doe managed to retain pro bono counsel within 20 days, and that counsel was able to research, draft, and file a motion to quash within 30 days after that. In the meantime, Reddit was still in negotiations with Watchtower, meaning that any delay in moving forward could not have prejudiced Watchtower, which has itself chosen to wait to compel disclosure. Although this motion is timely, even if it were not, the circumstances would overwhelmingly warrant its consideration over a finding of waiver. Finally, to the extent Watchtower contends that this court lacks jurisdiction to adjudicate a copyright claim against Doe, that contention is fatal to its subpoena. This court's subpoena power does not extend its jurisdiction. Accordingly, if this court decides that Doe has no connection to the U.S. and does not benefit from the First Amendment's protections in any respect, this court should recognize its lack of personal jurisdiction over Doe and hold the subpoena void on that basis. Watchtower cannot have its cake and eat it too. Personally, I like to reverse those. I don't know if I'm correct about this, but I was told that the original was, you cannot eat your cake and have it too. And I find that to be a little bit easier to understand the purpose or the meaning of the phrase. So Watchtower cannot eat its cake and have it too. Either Doe is subject to this court's jurisdiction because it has availed itself of U.S. law and therefore benefits from its protections, or Doe is not, and the subpoena is void. Either way, Watchtower's subpoena must fall. I don't know if they meant fall, but fail also works there. Watchtower acknowledges that the DMCA essentially requires the party seeking a subpoena to plead a prima facie case of copyright infringement for a subpoena to issue. Yet it has barely attempted to establish even the prima facie case required. Specifically, Watchtower has failed to show ownership of a valid copyright with respect to the chart, or any violation of an exclusive right of the Copyright Act with regard to either the chart or the ad. With respect to ownership, Watchtower admits it has not registered the chart. Thus, the only basis for its ownership claim is simple assertion. And as a footnote here, Watchtower does not need any information about the defendant to register its own copyright, nor can it obtain statutory damages for any infringement occurring prior to registration. While Watchtower could in theory recover lost profits or disgorged those earned by Doe, here the chart is a non-commercial work that was posted for non-profit purposes with no means of generating revenue. Thus, in reality, Watchtower cannot recover any damages at all for the chart now that Doe has removed the chart from their post on Reddit. Good point. In addition, Watchtower has offered nothing to suggest it made creative and original choices to justify treating a spreadsheet of factual and legal information as copyrightable. Charts were not copyrightable where the plaintiff arranged factual data according to purely functional grids that offer no opportunity for variation. The format of the charts is a convention. The plaintiff exercises neither selectivity in what he reports nor creativity in how he reports it. Because the plaintiff's charts do not demonstrate the requisite minimal originality, they are not entitled to copyright protection, and the defendant's use of them cannot constitute copyright infringement. We have to take a small break here, everyone. We have a guest in the studio. If the guest would like to get up on my lap. Here we go. There is my Nico. Everyone say hi to me, Nico. All right. How are you, boy? Would you like to grunt into the microphone? No, he's grunting, but not very loud. If I give you another one, will you grunt? Oh, but he'll reach for it. He'll reach for it. Arr. All right. Ready to go? All right, good boy. Go lay down. Where's my Ilsa? Apparently not there. All hail Nico, says Aspernari. Bring this back in. All right. Let's move on. Instead, Watchtower simply argues that Doe's modifications were not creative. That argument goes to fair use, not copyrightability. Watchtower persistently characterizes Doe as an infringer. In fact, Doe simply made fair use of the material, and fair use is wholly authorized by law, citing Lentz v. Universal Music, the Ninth Circuit 2016 case, establishing that fair use must be considered. And I believe certiorari was denied, so the Supreme Court was not willing to take up an appeal, which means they somewhat tacitly agree with the Ninth Circuit's ruling that fair use is a right and must be considered, etc., etc., etc. By sharing Watchtower's works with a community of former and questioning Jehovah's Witnesses in order to inform discussion, Doe intended to use the ad-end chart to promote fair and reasonable criticism, as well as understanding of Watchtower's practices. As the Supreme Court has recognized, fair and reasonable criticism lies at the heart of fair use. That's from Harper and Row Publishers. And notwithstanding the provisions of Section 106 and 106A, which are copyright rights and fair use, or some of the 106A is a couple extra rights. The moral rights are our version of them, and 107 I think is fair use. The fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. On the first factor, Watchtower does not seriously challenge the beneficial and transformative purpose of Doe's post to the public. While it emphasizes the fact that Doe posted a copy, it does not dispute that these posts were non-profit and educational rather than commercial in nature. Harper and Row makes clear that the crux of the profit-non-profit distinction in the fair use analysis is whether the user stands to profit from the exploitation of the copyrighted material without paying the customary price. Here, there is no reason to suppose that Doe profited or sought to profit. Factor 1 favors fair use. While Watchtower contends that the ad and chart are creative in nature such that the second factor weighs against fair use, it offers no factual support for that contention. Assertions supported solely by attorney argument should be disregarded. Moreover, the documents themselves tell a different story. The ad, a request for donations, is both published and primarily informational, both characteristics that weigh in favor of fair use. The chart is even less creative, and the cases Watchtower cites do not suggest any other reading. Watchtower looks to Edwin K. Williams and Company versus Edwin K. Williams and Company et al. I think that's what that means. But the copyright content at issue in that case was the original creative and non-functional material included as part and parcel of a form. Among other things, the document concluded with tips on keeping regular records and using incentives to motivate employees. Make a game out of seeing how early each day you and your men can sell enough to cover the daily operating expenses. The court in Continental... I don't even know what the CAS abbreviation is. Versus Beardsley similarly relied on explanatory language that was inseparably included in the bonds and affidavits, which constitute the means for the practice of his plan. In Kregos versus Associated Press, the court merely rejected the defendant's argument for fair use as a matter of law. Moreover, while the factual compilation apparently lacked explanatory language equivalent to that in Williams and Beardsley, the form itself was original, etc. Here, the form at issue is a standard Microsoft Excel spreadsheet that Watchtower did not originate. As for Factor 3, Doe does not contend the entire works were merely relevant. To the contrary, displaying them in their entirety was essential to Doe's informational purpose. Doe reproduced the ad and chart in their entirety as was necessary. Doe could not have used any less of the ad and chart to convey the same or equivalent information to others. As explained in the motion, posting the entire chart was necessary to show people how the organization was handling all personal data in compliance with all applicable legal provisions. Watchtower suggests Doe should have re-summarized the chart contents, but the chart is already a summary of the relevant legal and factual information it contains. Doe also explained why using the ad was necessary, so people could see that the entire back page of the magazine was being used for financial solicitation activities, and that it had the look and feel of an advertisement as a whole. Watchtower argues Doe could have achieved the same effect by linking to its website, but that would have prevented users from viewing the ad in the same window as users' comments, including while providing their own comments on both. Moreover, using the entire chart and ad was necessary for Doe to show that the information being conveyed came from the Jehovah's Witnesses and was not being mischaracterized or altered in transmission. As for the fourth factor, the central question is whether the use supersedes or substitutes for the original in any actual or potential market. That's Campbell v. Acuff Rose Music. Doe's use does not supersede or substitute for the original chart or ad. First, there is no imaginable market for either work, and Watchtower does not claim otherwise. Second, Doe posted relatively low-resolution images of the chart and ad that could not be enlarged or reduced without losing clarity. Even if a market existed, these images couldn't serve as a substitute for the originals. Indeed, the only market harm that Watchtower can muster is speculation that the ad might divert viewers from the magazine on Watchtower's website, but the ad is only the back page of the magazine, an unlikely substitute for a whole magazine. Moreover, Doe posted these images in order to call them to the attention of members of the XJW subreddit, which could encourage them to visit the Watchtower website to learn more for themselves. Finally, even this highly speculative harm has no bearing on the chart. Watchtower, based itself in the United States, is asking this court to uphold a subpoena to a U.S. corporation in this district requiring disclosure of information about a user of that corporation's U.S.-based speech platform, but not to apply the First Amendment to that request. None of the cases it cites support that request or even concern anonymous speech. Watchtower instead cites inopposite cases involving foreign nationals, including enemy combatants, asserting one, that the Fourth and Fifth Amendment with respect to two constitutional violations occurring in countries other than the U.S. Those cases are not persuasive here. The First Amendment independently limits the government's ability to abridge speech. In that respect, it is unlike, say, the Fourth Amendment, which begins by speaking of the right of the people to be secure in their persons, houses, papers, and effects. By contrast, the First Amendment begins by focusing upon the activity of the government it says that the Congress shall make no law abridging the freedom of speech. In Heffernan, that does, it looks like Heffeman. In Heffernan, the court relied on the principle to hold that government action can violate the First Amendment by abridging freedom of speech, even if the speech at issue is not itself protected. There, a police officer was fired for holding a protest sign, which it turned out he was only carrying to deliver to his mother, not to express his own views. Even though the officer had not engaged in protected speech activity, the court held that terminating him on the basis of speech was still unconstitutional because the harm was the same as telling the others that they engage in protected activity at their peril. Given the First Amendment's robust protection for free speech, courts have rejected the idea that the First Amendment is inapplicable to extraterritorial publications. A case, Desai versus Hirsch. For example, the court refused to apply India's defamation laws in U.S. judicial proceedings relating to the publication of a book that was distributed in India. The court did not base its decision on the fact that the defendant was a U.S. citizen, but on the self-evident principle that extending First Amendment protections to extraterritorial republications of speech in certain instances may be necessary to ensure the free flow of information to the American public. The point was not to chill speech inside the United States relating to matters of public concern, and it might be necessary that First Amendment protections spill over to more extensive extraterritorial republications of that speech, given the ease and likelihood of extraterritorial republication. The court thus concluded that for purposes of suit in a United States court, the First Amendment would follow the speech throughout the international stream of commerce to protect extraterritorial and republications, or just to protect extraterritorial republications. Watchtower attempts to avoid these holdings by turning to a collection of inopposite cases. In one of those cases, Johnson v. Eisentrager involved enemy combatants asserting that their trial, conviction, and imprisonment violated Articles 1 and 3 of the Constitution and Fifth Amendment. Contrary to Watchtower's interpretation, the Supreme Court did not categorically reject any non-citizen's right to invoke the Constitution, but rather acknowledged that the alien, to whom the United States has been traditionally hospitable, has been accorded a generous and ascending scale of rights as he increases his identity with our society. And the court emphasized that the disabilities this country lays upon the alien who becomes an enemy are imposed temporarily as an incident of war and not as an incidence of alienage. U.S. v. Verdugo Urquidez is equally unpersuasive. In that case, the court reviewed a warrantless search that took place in Mexico and allegedly violated the Fourth Amendment. As the court noted, the defendant was a citizen and resident of Mexico with no voluntary attachment to the United States, and that if there were a constitutional violation, it occurred solely in Mexico. Here, by contrast, a constitutional violation would have occurred in the U.S., specifically this district, where the court order compelling Reddit would issue and be effected. And the harm due to the abridgment of speech would be felt here as well. Watchtower contends that other commentators have not yet been silenced by this suit, but it does not dispute the fact that Doe has fallen silent and stopped posting on the XJW subreddit altogether as a result of its subpoena. If the court orders Doe's identity disclosed, Doe will remain silent, and that will abridge access to speech across the U.S. Watchtower relies heavily on the case Signature Management versus Automatic, spelled with two T's, Automatic, in MATTIC. In fact, the case weighs in favor of quashing the subpoena. I did it. I called it a motion to squash. In fact, the case weighs in favor of quashing the subpoena. First, with respect to the copyright claims, the Doe in Signature 1 distributed an entire textbook verbatim on a blog. Here, Doe's post included two simple images, and that posting was a classic fair use. Second, both the district court and the appeals court in Signature Part 1 specifically recognized the importance of protecting anonymity in both anonymity in copyright cases, both prior to and even after adjudication of infringement. Importantly, the district court did not permit the doe's identity to be publicly disclosed during litigation. To minimize the interference with free expression, the court ordered that any information disclosed to plaintiff in response to the subpoena may not be disclosed to anyone other than the parties in this action and their counsel of record without further order to this court. Accordingly, the user was able to minimize the disclosure of their identity during discovery and through summary judgment. After Doe was found liable for copyright infringement, the plaintiff again sought to unmask Doe. On appeal, the Sixth Circuit still declined to order public disclosure. Instead, it remanded to the district court to weigh the presumption of public access to court records and the harms of disclosure in the context of the user's anonymous speech activities as a whole. It explained, although Doe's infringing speech is not entitled to First Amendment protection, that speech occurred in the context of anonymous blogging activities that are entitled to such protection. An order unmasking Doe would therefore unmask him in connection with both protected and unprotected speech and might hinder his ability to engage in anonymous speech in the future. Doe's anonymous blogging history on the XJW subreddit here should similarly factor into this court's consideration of the harm disclosure would cause. Watchtower admits that Doe has engaged for years in lawful anonymous blogging activities that spark no allegations of infringement. That whole history should be considered before Doe's identity is disclosed well in advance of litigation, let alone any adjudication of copyright infringement. The fact that some users are willing to speak freely without fear of facing the same consequences Doe faces does not negate the chilling effect the subpoena has already had on Doe or the likelihood that it will encourage others, including those who may already be unwilling to speak out, to stay silent. But this case is unlike Signature in a key respect, the putative plaintiff. Watchtower is part of the very organization and community within which Doe is trying to shield his identity. While Watchtower asserts that it cannot excommunicate Doe because it is not Doe's local church, but it could disclose Doe's identity to their local church, which could then take further action. But formal excommunication or disfellowshipping is not Doe's only concern. They also fear being socially isolated as community members as community members bow to internal pressures to distance themselves and eventually cut ties with those that voice unpopular opinions. Watchtower does not deny the likelihood of these harms, nor offer to take any step that might prevent or mitigate their effect. The only proof or assurance Watchtower offers is that the subjects of Watchtower's DMCA subpoenas who were Jehovah's Witnesses before Watchtower learned of their identities via DMCA subpoenas, they continue to be Jehovah's Witnesses. Watchtower's assertion that these individuals remain Jehovah's Witnesses is simply irrelevant to the concerns Doe has voiced based on their first-hand experience over the course of their lifetime. And then we get on to the timeliness part. The 14-day deadline for objections to a subpoena does not apply to John Doe. As a party to whom the subpoenaed records pertain, Doe cannot simply object. They must move to quash the subpoena instead. Rule 45 states that a party cannot rely on objections to a subpoena served on a non-party, but must instead file a motion to quash or seek a protective order. A motion to quash is not subject to the same 14-day deadline as subpoena objections. It must simply be timely. As the leading commentator and the case law they rely on explain, the 14-day requirement to object to a subpoena is not relevant to a motion to quash a subpoena. Even if the 14-day deadline for objections were applicable in unusual circumstances and for good cause, the failure to act timely will not bar consideration of objections to a Rule 45 subpoena. Courts have found unusual circumstances where 1. A subpoena is overbroad on its face and exceeds the bounds of fair discovery, where 2. The subpoenaed witness is a non-party acting in good faith, and 3. Counsel for the witness and counsel for the subpoenaing party were in contact concerning the witness's compliance prior to the time the witness challenged the legal basis for the subpoena. That means even untimely objections may be excused. All 3 sets of unusual circumstances are here. First, Watchtower's subpoena exceeds the bounds of fair discovery by seeking to overcome the First Amendment privilege that applies to attempts to unmask anonymous speakers in discovery. Moreover, given the discretion courts have over discovery matters, where a constitutional privilege is involved, a trial court possesses the discretion not to find a waiver of the timeliness. This is particularly true, as the district court noted, where the alleged waiver is accomplished by inaction rather than action. Second, Doe has not been sued and is not a party to any litigation. Doe is a private individual with limited resources who lives overseas. Doe has been acting in good faith and with extreme diligence in retaining counsel within 20 days and having counsel draft and file a motion within a month of being retained. Third, Watchtower and Reddit's counsel are continuing to confer over the subpoena and to the best of Doe's knowledge. Given Watchtower's ongoing dispute over the scope of the subpoena with its recipient, Watchtower cannot seriously argue it inferred any waiver from Doe's inaction or suffered any prejudice from a delay in compliance it could not have obtained regardless. If this court lacks jurisdiction, here's that jurisdiction thing we were talking about before, then the subpoena to Reddit is void. Watchtower contends that Doe admitted a lack of personal jurisdiction. Citing their opposition, Darkspilver seeks to invoke First Amendment rights in a court that, by his own admission, does not have the requisite personal jurisdiction to adjudicate the copyright claim. Doe's motion to quash did not, in fact, challenge this court's personal jurisdiction, given Doe's purposeful availment of the First Amendment in that motion. Purposeful availment, that's a code word there. That's invoking the International Shoe v. Volkswagen and Bell Atlantic v. Twombly. That's jurisdictional. Those are the jurisdictional cases, two major jurisdictional cases, and purposeful availment is one of the ways you get jurisdiction. But to the extent Watchtower contends this court lacks personal jurisdiction to adjudicate a copyright claim against Doe, that contention renders its subpoena void. In U.S. Catholic Conference versus Abortion Rights Mobilization, a 1988 Supreme Court case, the court held that the subpoena power of a court cannot be more extensive than its jurisdiction. That means that if the court does not have subject matter jurisdiction over the underlying action and the process was not issued in aid of determining that jurisdiction, then the process is void and an order of civil contempt based on refusal to honor it must be reversed. In recognition of these limits, the court in Sutcliffe v. TubeSock Ted refused to unmask a pseudonymous web user, partly because the user, a Minnesota resident, would not have been subject to personal jurisdiction in the case in Washington, D.C. There was no basis to believe that the copyright owner can establish personal jurisdiction over the defendants. Sinclair's anticipated response that defendants' statements posted on the internet can be downloaded and viewed in the District of Columbia is insufficient to establish personal jurisdiction, even if Sinclair were located here rather than in Minnesota. As Doe has stated, and Watchtower does not dispute, Doe does not live in the U.S. and was not in the U.S. at any time relevant to this case. To the extent that deprives the court of personal jurisdiction over Doe, it renders the subpoena void as well. For the foregoing reasons, Doe respectfully requests that the court quash Watchtower's subpoena to Reddit, rather than restrict speech on the basis of facially specious copyright claims. Respectfully submitted, Alexandra Moss and Corinne McSherry from the Electronic Frontier Foundation. I think that's a really impressive reply there. I'm kind of proud of myself because I think we called about 75% of those arguments. And I'm really happy to see that I think like a lawyer, which is always reassuring when you are actually a lawyer. I hope everybody gets that joke. Also, one of my favorite hats back there, my EFF hat. Love the EFF. You guys are the best. I aspire. So then what has happened? So we've got some new things happening here. Let me make sure I've got everything open here in Firefox. Yeah, we'll start here. So then yesterday, or I guess 2 days ago, we received notice that a 14th document, if you take a look here, this is the 13th document. So then a 14th document was filed. It's almost like they knew. It's almost like these two parties had talked to one another, the EFF here and whatever this party is. What party is this? It is Reddit. So this is of course the Reddit that the subpoena is to. and Reddit has filed a joinder to EFF's motion to quash. Now, there's a date and time here. This is not necessarily a set in stone date, but usually when you have a opposed motion, a non-consensual motion, a federal court will make you choose a motion hearing date, and you usually have to arrange it with the court's clerk, or sometimes you just choose a hearing date and then everybody shows up and you all argue. Sometimes the court will then order an actual date. And then the thing that made me jump out on my seat here was that Reddit has hired Duri Tangri and none other than Joseph Gratz. Now, I know we don't talk about individual attorneys a whole lot. We've mentioned some bad ones, and we don't often talk about how awesome the good ones are. Joe Gratz is an amazing attorney from a firm called Duri Tangri in San Francisco. I don't actually know too much about their firm. Joe and I met at a law conference, I don't know, 6-7 years ago when I first started practicing, and he's a total geek like me. If you like me, you'd love Joe. So Joe has a remarkable past, and I thought we should go over his profile a little bit here. This is his profile on duritangri.com. He is a litigator as comfortable on his feet in court as hashing it out over source code with a group of engineers. He has recently, I don't know how recently, become a partner at Duri Tangri after being their very first associate. But here's the part that I wanted to share. Joe has litigated a number of important internet copyright and trademark disputes. He represented Google in the Google Book Search copyright case and in the RescueCom v. Google and Vulcan Golf v. Google trademark cases. In a pro bono case, he argued and won the Ninth Circuit Court of Appeals case on behalf of Troy Augusto, an eBay seller of promotional CDs who had been sued for copyright infringement by the world's largest record company. He also authored copyright amicus briefs on behalf of Google in FlavaWorks v. Gunter. FlavaWorks is one of those sort of copyright trollish, maybe. I'm not accusing them. I'm just saying, they're doing trollish activities of suing people for copyright infringement generally. You might remember Carew v. Prince was another one, the Second Circuit case of Carew v. Prince. There was an amicus brief in Wiley versus Kurtzsang. You remember we talked about that, representing the interests of independent bookstores. He previously represented Shepard Fairey in the fair use litigation over the Obama Hope poster, represented the Boing Boing blog, Cory Doctorow's blog, in copyright litigation brought by Playboy magazine. That was when Playboy had sued or was threatening Boing Boing. Boing Boing had linked to a archive of Playboy magazines, let's put it that way. Joe currently represents Upcodes in litigation arising out of the public posting of state and local building codes. He has defended technology companies against patent infringement for various things, and he has led his team to victory in the Electronic Frontier Foundation's Cyber Law Pub Quiz 2008, 2011, 2012, 2015, and 2017. So I just wanted to share how remarkable it is that Joe Gratz has joined the fight on behalf of Reddit, sort of on behalf of Darkspilver then. I mean, I'm not saying that he represents Darkspilver, but rather if those two parties are working together to fight this subpoena, it's serious. If you have a lawyer like Joe Gratz and you have a party like Reddit joining the fight with Darkspilver, who has the EFF behind him. So then, that is not all. That is not all I have for you then. This spurred an immediate response from Watchtower, and I have that document for you as well. So finding that Reddit was joining the fight and not being happy to hear about everything we just talked about, Watchtower Bible and Tract Society of Pennsylvania has opposed Reddit's joinder of the motion to quash. Now, you're going to hear some things here from the Federal Rules of Civil Procedure about joinder. What is joinder? Joinder allows someone to join in a lawsuit as a party. Well, this is not a lawsuit yet. Yeah, you're going to hear that argument. and some other things. Is Reddit a party? The copyright claim is not against Reddit, so they're not a party to a lawsuit. You're going to hear all this, but I just wanted to get your mind going. We're talking about when it's allowed that two plaintiffs can join in, or two defendants can join in on something in a lawsuit. So we're going to talk about that a little bit here. And this, of course, is Watchtower's side. So they're against the joinder of Reddit. With all briefing already filed and oral argument only 2 weeks away, Reddit informs the court that it has unilaterally decided to join Darkspilver's motion to quash without so much as a respectful request for this court's permission to do so. Should the court construe Reddit's filing as a request for permission to join Darkspilver's motion to quash, Watchtower Bible and Tract Society of Pennsylvania opposes Reddit's motion. Reddit's 11th hour attempt to join Darkspilver's motion to quash is out of order and should be summarily rejected. The issues to be decided in this present matter are: 1. Whether Federal Rule of Civil Procedure 18 permits Reddit to join Darkspilver's motion to quash when no claim, counterclaim, cross-claim, or third party has been filed. Whether Federal Rule Civil Procedure 19 permits them to join where Darkspilver is not a party to a pending lawsuit and no pleadings have been filed. And whether Federal Rule Civil Procedure 20 permits Reddit to join Darkspilver's motion to quash when Darkspilver is not a party to an action before this court and no pleadings have been filed. Well, that's sort of half true. If we go back to their motion here, we don't see what the basis is. Reddit hereby joins the motion to quash is all that it says. It does not say under Federal Rule Civil Procedure 18, 19, or 20. So let's just keep that in mind. The federal rules do not permit joinder in the present circumstances. Reddit did not file the present joinder notice until 2 weeks before oral argument on a fully briefed matter. Further, Reddit asserts no basis for the joinder. Rule 18 does not permit joinder where no claim has been filed. Okay, well, they're going to list the rules here, so I don't have to do it, I guess. I have them all prepared here in Firefox. Rule 18 provides that a party asserting a claim, counterclaim, cross-claim, or third-party claim may join as independent or alternative claims as many claims as it has against a opposing party. That's a may in there, so it's not, that's a permissive joinder. Rule 19 says that a person is required to be joined who is subject to service of process and whose joinder will not deprive the court of subject matter jurisdiction, and they must be joined if basically there's some complicated rules here. If the court cannot adjudicate their claim cannot adjudicate the existing claims in their absence, so that's not going to apply here either. And Rule 20 says that persons may join an action as plaintiffs if they assert any right to relief jointly, severally, or in the alternative with respect to or arising out of the same transaction or occurrence. This is the transaction or occurrence language. Or as defendants, persons as well as cargo or a vessel or whatever, when we're talking about property being sued, may be joined in one action if any right to relief is asserted against them jointly, severally, or in the alternative with respect to arising out of the same transaction or occurrence, and any question of law or fact common to all defendants will arise, etc. So then they go on to say that there is no plaintiff or defendant in the present matter because no complaint has been filed. Unlike typical subpoenaed issues in cases which pleadings have been filed, the Digital Millennium Copyright Act provides the basis upon which the present subpoena was issued. Reddit attempts to treat the present subpoena as if it is based on a claim for which pleadings have been filed. Such treatment is simply premature. No pleadings have been filed. There are no parties to an underlying action as yet. As such, there is no basis for Reddit's joinder to Darkspilver's motion to quash. Watchtower respectfully requests this court rejects Reddit's attempt by notification to insert itself into the pending motion to quash. So that's a strange argument. And the reason why I think it's very strange, I've practiced federal law here for several years, and I have never, ever, ever seen a judge deny adjudication of a matter because of a technicality like this. Would a court say that the DMCA 512H provision allows the subpoena, but that there's no plaintiff and that there's no defendant, and therefore rules 18, 19, 20 don't apply? Well, even if rules 18, 19, 20 don't apply, I don't see how the court can't recognize that the subpoena is to Reddit and is for Darkspilver's identity. Therefore, at least those two parties are parties to the case. The subpoena is to Reddit, so Reddit's definitely got the right to respond and object. And Darkspilver is it's their identity that's being sought. And there's lots and lots of case law that says that when it's your identity being sought, you have some kind of standing to respond. So I don't see Reddit as being denied the opportunity to argue their side of this. Now, they've joined the EFF's motion to quash, Darkspilver's motion to quash, so we know whose side they're on. But they're going to tell their version and their arguments, hopefully during actual legal arguments or actual oral arguments in front of the judge. So we'll get to see that. So while you have me, ask me some questions. Otherwise, I'll grab some dogs, or maybe we'll grab some dogs while we're taking it out here, because that's really all I have for you as a show today. I don't want to keep you long for any reason. You guys, it's a beautiful day outside. For at least it is here still, I think. So my window's all covered up because of the light diffuser. So I just tried to look out a closed window, basically. Anyway, love you all. I'm Leonard French, and this is Lawful Masses, your legal education channel of choice. Thank you to our community supporters. This is a viewer and community-supported legal education channel. Thank you to our sponsus.org/u/lawful masses supporters. Thank you to our patreon.com/LJ French supporters. We also have twitch.tv/lawful masses, and I don't even know what our YouTube short name is. I think it might be Lawful Masses as well. You can just search for Lawful Masses with Leonard French. Thank you to our April supporters at the $50 level: John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Aspernari, Snorre Wisotzky, Sean McNamara, Aetaric, and thank you to the $5 plus supporters, which are already in the description below, because I thought about all of that ahead of time today, because I'm getting better. So if you are looking for a quick recap, Reddit has joined the Electronic Frontier Foundation in their fight to suppress the Watchtower request for Darkspilver's identity. And the EFF has responded to the Watchtower request to deny the motion to quash. This is complicated, right? You got to think it's like ping pong back and forth. So Watchtower still wants a subpoena, so they file a brief in support, and now we have the Reddit reply. So we went over that, and the reply hit the things that we said that they'd hit. The chart is not copyrightable, the uses are fair, the timeliness is not an issue, and the ability to respond is not waived. So I think that that's all very good arguments, and I'm looking forward to hearing what the judge has to say. If there was any way that I could make it to these oral arguments, I would love to do that too. It's not a terribly long flight. It's usually just a rather large expense for something that's not certain, because you could get there, the thing could be continued. There's really no reason to fly out someplace on such uncertainty. Maybe we could send somebody, though, or maybe Joe Gratz would like to talk to us afterwards. How would you like that? Any questions? Otherwise, I'll grab a dog and play some music here, and we'll take it out. Nico. My Nico boy. Now you're not supposed to be. I'm not supposed to be feeding you as much. You're like 10 pounds overweight for an 88-pound dog. Hup. Yeah. Come on, Hup. Up. Good boy. Good boy. So, yep, he's got... Hey, no, don't eat those off the table. You're supposed to eat them on the camera. All right, so this is Nico. Ilsa is somewhere. Hey, Ilsa. You want a treat? It would be cool to get an interview with Joe Gratz. I haven't asked him, so that's sort of half the fault of not having too many interview guests, is I never really ask anybody. So we should ask Joe Gratz to see what he has to say. You having a good day? We went for a car ride before. It's nice outside here. So we're going to go, well, let you outside, but I'm probably going to go play some Rocket League with Kelly. Okay? Thank you guys for joining me. How many of you did there end up being? Let's take a look here. We have 413 of you right now. That's amazing. You guys are great. Oh. Nico thinks so too. You're a good boy. You want some more? Okay. Okay. Come on. No, come on, hop. Hop. He thought I was saying okay off. No, you stay hop. You're a good boy. You can stay hop. You can stay hop. Yeah, you're a good boy. Yeah. Alright, so I'll leave this up as a video for you to comment on and all that. I look forward to your discussion. Subscribe if you'd like to see more news. We're going to be keeping an eye on this case and several others. And go watch some of our other videos. Love you all. Where's my Ilsa? I guess Ilsa's outside. Yes, the gate is firmly screwed shut, and we're actually going to put up a second gate. And I don't know, I might even make a video about that. Alright, 24 seconds. Thank you everyone who donated. Thank you, Aspernari. I think I have a list here, actually. Somewhere, no. Open super chat. Yep, thank you, Matthew and Aspernari and John Roddy and Sarah Marie and Aspernari, and Matthew again. Thank you very much, everyone. Love you all. I'm Leonard French, your favorite copyright attorney, and I'll see you on Sunday for the Sunday show.